hearsay. You're asking for my client statements?
Yes, he's Remy.
Objection to hearsay. So my objection to hearsay again.
She hasn't presented a statement for you to make an objection to. I think it's actually been rather artful.
Thank you, Jack.
Welcome to Bench Report Court Cam.
We do the hearing on Mr. Calendar.
The young guy. Was it Remy or Remy?
Mr. Remy Martin Jones.
Yes, Your Honor.
Let's go ahead and do that, and that way we can get the officer back out.
Officer Josias, can you please turn your camera on? Hope I said that right. Josias?
Yes, you said it right, ma'am.
Okay, perfect. Thank you.
Give me one second. Let me turn on the camera. A second.
All right.
Your Honor.
Yes.
Well, I guess we'll get
Yes.
started. Stand right here.
Bring it up a little bit closer to you. Okay.
Just check.
And this is Mr. Remy Martin LaShawn Jones.
Yes, ma'am.
All right, so this is the hearing for the petition for revocation of probation for State of Georgia versus Remy Martin LaShawn Jones, case 2023 CR 05863. Defendant was entered a plea before this court for criminal trespass on the second day of May 2024. He was sentenced to 12 months on probation. He has 5 months and 19 days remaining. His sentence was not told. It is alleged that he violated the law by having the new offense of battery family violence on October 7th of 2024. He failed to complete community service. He has documented 4 hours as of September 9th of 2024, and he failed to pay. He is currently $320 in arrears. Mr. Jones has requested a full hearing, and Mr. Officer Josias, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand out. Your witness, ma'am.
Thank you, Judge. Please say your first and last name for the record.
I'm Officer Josias with the Forest Park Police Department.
I'm sorry, what's your first name?
Officer Josias.
Your first name?
Oh, Valandi. Officer Valandi Josias.
Okay, please spell that for the record.
The first name is Valandi, Valandy. Last name is Josias, Julceus.
And Officer Josias, excuse me, how are you employed? Excuse me. How are you employed?
I'm employed with the Forest Park Police Department.
And how long have you been employed with the Forest Park Police Department?
For 2 years.
Okay. And were you employed with the Forest Park Police Department on October the 7th of 2024?
Yes, ma'am.
Okay. And are you post-certified and credentialed?
Yes, ma'am.
And are all of your credentials up to date?
Yes, ma'am.
And were you post-certified and credentialed on October the 7th of 2024?
Yes, ma'am.
And do you have arrest powers?
Yes, ma'am.
And did you have arrest powers on October the 7th of 2024?
Yes, ma'am.
And were you on official duty and working in your official capacity on that day?
Yes, ma'am.
And on October the 7th of 2024, were you dispatched to 1058 Phillips Circle, Forest Park, Georgia, 30297?
Yes, ma'am.
And what county is that address located in?
Clayton County.
Thank you. Let the record reflect that venue has been established, Your Honor.
Records shall reflect that.
Thank you. And is this a residential or commercial location?
That's a residential.
And what was the nature of the call?
a disturbance call.
I'm gonna object to hearsay at this point. Judge, there's a dearth of case law that supports the fact that hearsay is not admissible in probation revocation hearings. And neither does the client also has the right to confront the witnesses against him. So this will be my first of many hearsay objections I'm anticipating.
Well, Your Honor, the officer was responding as part of his duties, as part of an investigation to this location. So
Right. But the question asked for,
what was the nature of the call?
okay, we can go on to where you get into the hearsay.
All right, what was the nature of the call is not hearsay. So go ahead, you can answer that, sir.
Yeah, I was dispatched to that location in reference to a disturbance call.
Disturbance, okay.
Yes.
And upon during that call, was there anything specifically said about the disturbance?
Objection, hearsay, calls for hearsay.
Your Honor, again, it's going to the officers responding to the incident location.
He's asking for a statement for the truth of the matter asserted in that statement. That's classic hearsay. There's no exception noted. Calls for hearsay.
Sustained.
Upon your arrival, did you make contact with anyone?
Yes, I did. I made contact with Zena Jones, Remy Jones, and Zakisha Leon.
Okay. So you said you made contact with Zena Jones, you said Remy and Zakia.
Yes, ma'am.
Okay. When did you speak to Remy Jones?
Yes, ma'am.
Okay. And what did you learn during that? During your
Objection,
communication?
calls for hearsay. She's asking for a statement, even if she doesn't say what did she say. She's asking.
Wait a minute.
He's a defendant, Your Honor.
Asked if he spoke to Remy, correct?
She asked what did you learn from speaking to Remy, which is calling for Remy's statements, which is hearsay.
Admission by a party
Remy,
opponent.
yeah, Remy's the.
No, Remy is not. You're asking for my client statements?
Yes, he's Remy.
That's his name.
All right, okay.
And thank you, Judge. And what during your communications with Remy, what did you learn?
I learned that when I confronted Remy of what's going on, he stated that the victim at the time, her name is the victor, Miss Jefferson, Andrea Jefferson, assaulted her mother. Well, his mother, due to the fact that they got into a verbal altercation about her not being able to stay inside of the house.
Okay. Did you speak to the victim in this case, Miss Jefferson? You said.
Yes, I spoke to Miss Jefferson, Andrea Jefferson. After.
I'm gonna. Okay, excuse me.
And when you spoke to Miss Jefferson, what was her demeanor?
When I spoke to Mr. Jefferson, she was upset. She was she stated that she was assaulted.
Objection, hearsay.
So when I spoke to,
we will argue present sense impression. The victim is describing and also state of mind. Her present state of mind. She's describing the incident to the officer as well as her state of mind at that time.
Judge, this testimony violates my client's due process rights under the Confrontation Clause, which does apply to hearsay, which does apply to probation revocation hearings. It is hearsay. It's not admissible. There's no exception noted to the Confrontation Clause. She's not here. If the state wants to present the statements of the alleged victim in this case, that person needs to come and testify and be subject to cross-examination.
Sustained.
Thank you, Judge.
So you said her repeat. What was her demeanor?
She was highly upset. She was highly upset.
Okay. Was she crying?
Yes, ma'am. She was crying.
Was she hysterical?
Yes, ma'am.
Did you notice anything else about Ms. Jefferson's demeanor?
Um, she appeared to have several visible injuries, marks on her body, on her
Okay.
face.
So you observed visible injuries to her body?
Yes, ma'am.
And I'm sorry, where were the visible injuries located?
And her face, on her face area, left, right side area on her neck, and also in her boobs area.
So you noticed visible injuries in her neck and you said boobs area?
Yes, ma'am.
Did you notice visible injuries anywhere else?
No, ma'am.
Okay.
And her hands as well. I'm sorry. Yes. She also has some scratches on her fingers.
You said fingers?
Yes.
Fingers, okay. Okay. And doing your investigation, were you able to determine how the victim sustained these injuries?
Objection calls for hearsay.
Yes, ma'am.
I know.
Well, I mean, there are other ways to ascertain something. He
Okay,
could have seen a video. There's lots of ways. So let's get to the response before you yell hearsay.
but I would just ask that the witness not make reference to any statements that were given to him, since that's what the state is trying to get at.
Okay. Sustained to the extent that there's hearsay, but I haven't heard anything because the office hasn't been able to respond to the question. Go ahead.
Thank you, Judge. And during your investigation, were you able to determine how the victim sustained these injuries?
Yes, ma'am.
And how are you able to make that determination?
Due to verbal statements, witness.
Objection to hearsay.
Your Honor, he just said verbal statements of witnesses. He didn't go into what the statements were made.
Unless that witness is my client or there's a hearsay.
Mr. Lynch, he can tell me that's how he made the determination. He's not saying what they said. He's saying that in his investigation, his determination was based on statements made by various witnesses, but he has yet to give me hearsay.
Okay.
Thank you, Judge.
Overruled.
I believe you, okay, so you said verbal statements by witnesses. Were there any other ways you were able to determine how the victim sustained her visible injuries?
Based on what the victim was saying, it matches.
Objection, hearsay. He's going to go into based on what the witness was saying.
And then he said it matches.
Chill.
Go ahead.
To me
Well,
or
I
the
was-
officer, Your Honor?
State.
Officer.
I'm
Okay.
overruling the defense's objection. The witness may continue the statement he began making.
Okay. So if you can complete your statement, you were saying consistent and then you got cut off.
Yeah, I was saying, based on the witness statement with what was said, the story's not matching of what the defendants were saying and what witnesses were saying. So I came to a conclusion that whatever Miss Andrea was saying was right, because based on what other witnesses were saying.
Okay, so is it fair to say that Miss Jefferson's version of what happened was consistent with the other witnesses you spoke with?
Yes.
Okay.
And Judge,
And
I
I
have
believe,
to note my objection to hearsay. Again, she's trying to introduce statements that these witnesses said, compare them with each other, say that they're accurate for the truth of those statements, which is what she's trying to assert, is that those statements were true.
Mr. Lynch, she's essentially established is that the officer believed the statements and made decisions in the case based on those statements. He didn't say they were true, not true. He said in the way he was investigating the case, So she hasn't presented a statement for you to make an objection to. I think it's actually been rather artful. So continue, Ms. Hagler.
Thank you, Judge. And then Officer Jusius, do you see, you mentioned that you spoke with Zena, Remy, and Zakia. Do you see Remy in the courtroom today or virtual court? Yep.
I'm sorry, I muted myself. Can you
Okay.
hear me?
Yes. Do you see Remy in the courtroom today? Virtual
Yes, ma'am.
court. Okay.
Yes.
And is he the defendant in this case?
Yes, ma'am.
And can you please describe to the judge what he's wearing and where he's standing?
He's wearing a orange suit and he's standing behind his legal attorney, and he has a afro.
Okay. Your Honor,
And
let the record.
a white t-shirt underneath the suit, orange suit.
Okay, thank you. Let the record reflect, Your Honor, that Officer Jusius has identified the defendant in the courtroom.
Record shall reflect that.
Thank you. And during your investigation, were you able to determine if there were any primary aggressors?
Yes, ma'am.
Okay. Who were you able to determine to be the primary aggressor in your investigation?
Mr. Remy, Ms. Zena, and Sakisha.
Why did you determine the defendant to be one of the primary aggressors?
Once again, based on what one of the witness said, and matches what the victim has said.
Okay. And on that day, did you make any arrests?
Yes, ma'am.
And who did you arrest on that day?
I arrested Mr. Remy Jones, Zakisha Leon, and Zena Jones.
Okay. And what was Mr. Remy charged with?
Battery, family violence.
Okay. And why was he charged with battery, family violence?
I charged him with battery, family violence because Miss Andrea lived in that apartment and stayed in that apartment as well.
And did you take photographs of the injuries to Miss Andrea Jefferson?
Yes, ma'am.
You take photos? Okay. Okay. You got 1 second, please.
Yes, ma'am.
Your Honor, no further questions for Officer Jusius.
Mr. Lynch, do you have questions for this officer?
I do not.
All right. All right. Anything else for Officer Jusius?
Not from the state, Your Honor.
All right. Officer Jusius, you can be excused at this time. Thank you, sir.
Thank you, Officer.
Appreciate you. Have a good day.
All right. Anything else from the state?
No other witnesses, Your Honor, from the state.
All right. Anything from the defense?
Judge, we're not going to present any witnesses. We just have argument as to the alleged violation and the proof that was offered today.
All right. Is there a recommendation from probation?
Your Honor, in speaking with Ms. Hagler, I believe 5 months and 19 days, which is the balance, should be revoked.
No, I need you to give me a minute, okay?
All right. All right. Ms. Hagler, I'll hear from you, and then I'll hear from Mr. Lynch.
Yes, Your Honor. As the court did mention earlier, the defendant is currently on probation. That probation is still active. We just had a hearing. Officer Jusilis did testify that he did respond to the incident location at 1058 Phillips Circle in reference to a disturbance. Upon his arrival, he did make contact with the victim in this new case, Andrea Jefferson. He testified that he did notice visible injuries on Miss Jefferson. She had injuries on her neck, she had injuries on her boobs and her fingers. We also learned from the testimony today that the officer did determine the defendant to be the primary aggressor in this situation. Officer did testify that he also took photos of Ms. Jefferson's visible injuries. And he also testified that the victim's statements were consistent with other witnesses that he did interview on that day as part of the investigation. And as a result, the defendant was arrested on this new offense of battery family violence, as Ms. Jefferson did live in the same household as the defendant, Remy Jones. And so because, again, he has violated probation, which is still active, the state is requesting the judge to revoke his probation, and to revoke the 5 months, 19 days remaining. Thank you.
All right. That's correct.
Judge, the officer testified that he arrested 3 people. The officer testified that he observed injuries. The fact that my client was arrested and that he observed injuries does not meet the standard, which is preponderance of the evidence in this case. The alleged victim did not testify. There was no statements that the court, as you know, hearsay, if any did get in, has no probative value. I understand the officer made a determination that certain statements that we did not hear today were not consistent with one another. However, the court is left with the situation where 3 people, 2 additional people other than my client, were arrested for allegedly causing injuries or an altercation, which the alleged victim is in this case, without any statements or any evidence other than the fact that the officer made an arrest. That does not meet the standard of preponderance of the evidence. Additionally, in order to violate him based on allegations made by a person who did not testify, would violate his right against confrontation. The confrontation clause does apply to probation revocation hearings, Judge.
He told the officer that the lady jumped on his mother.
I'm sorry?
Mr. Remy told the officer that the lady jumped on his mother.
But, and Your Honor, she did, or he did, according to the testimony. But what you did not hear was he make any admissions as to putting hands on her. My client makes no such admissions. My client is placed in a predicament by this hearing where he would have to waive his right against self-incrimination because he still has a pending case. This is a pending case which he has the right to trial on, the right against self-incrimination, and the right to choose not to testify, and that's not to be held against him. So he made no admissions that he put hands on anybody. He did state that she jumped on his mother, who, according to the testimony, was also arrested for something in connection with this incident. And so you're left with a situation where you don't know who, and there's no evidence to get you to that preponderance of the evidence standard to show who may have caused the
preponderance of the evidence is a much lower standard than beyond a reasonable doubt. As Mr. Javaric used to say downstairs, and Judge, I understand it's a lower standard, but there's a standard. And
there is a standard, Judge.
But the officer testified that he was called to a disturbance. He spoke with all of the individuals there. One person had visible bodily injuries, Mr. Remy and Zakia and Zena. who all share the same last name, or at least Zakia and Remy share the same last name. Mr. Remy talked about the woman jumping on his mother. The woman who allegedly jumped on his mother was the one who had the visible injuries, and 3 people were arrested for battery. And so that's enough for me to make a probable cause determination that Mr. Jones is subject to having his bond revoked for violating his bond conditions.
Right, but we're on a probation revocation, Judge.
I mean, his probation revocation for violating his probation conditions, which one of them is to not get arrested again.
Judge, just to get away from arguing about the evidence,
Okay.
before you make any determination.
Okay, let me just say this. Mr. Jones is not new to me. He's been here a lot. And I don't want to hold his past against him, but Mr. Jones is here a lot. And he's getting to be one of those people who is going to be deemed not a good probation candidate.
Can I have one moment, Your Honor?
Yeah.
Judge, my understanding is that while he may have been in front of you before, he doesn't have a history of violent charges. He, he's on probation for obstruction, is my understanding, criminal trespass. Judge, as far as the allegation of simple battery, there are additional defendants in that matter. He has a right to be presumed innocent until proven guilty. As far as his performance on probation, he has completed more hours than have been documented. He's done at least 20 hours, he tells me, and he would be documenting that with the probation office as soon as he has a chance to. Judge, I don't believe there's any allegation that he's not reporting to probation. He's had, other than this arrest, there aren't additional criminal violations that have been raised. And I understand that the court has indicated that, yeah, and just a quick glance at his state court history, not the official version, but just looking on the website, I do not see anything violent, Judge. So to revoke the balance of his probation based on what, I disagree that the evidence met the preponderance of the evidence standard, but if it did, it just barely squeaked across the finish line, Judge. And Your Honor will be hearing that case.
Okay, here's the other issue, Mr. Lynch. So if I revoke and I revoke less than the balance, where does he go to? Because the other 2 defendants live in the home. The lady who was assaulted lives in the home, or was living in the home. I don't know where he goes that is going to keep him out of trouble until these cases are resolved.
He can speak to that, but he's telling me he doesn't have an issue staying away from the alleged victim in this case, Judge.
Why? Like, how do I know this? Because he was charged with battery family violence because she lived in the home. I don't know if she's related or if she's rooming, or I don't know all this because I didn't hear the hearsay. But my concern is this is just something that's going to reoccur. I don't have control over Zena and Zakia, but if he goes home, then my understanding is that there need to be some safeguards.
No, Judge, my understanding is they don't currently live together. The battery family violence could have been based on whether they previously stayed together. However,
That's not what the officer testified to. He said that she was in a a resident of the apartment where they live.
Regardless of what the truth of the matter is as to where she resides, Mr. Jones understands that he cannot have contact with her. And just to, and I know you're clear on this, but you know, the alleged victim in this case had nothing to do with the case he's on probation for. So
Yeah, I'm not.
previous to this, there was no stay away conditions. So he has not shown the court that he cannot abide by stay away conditions. He understands that a condition of his bond, which by the way, he is held on that misdemeanor charge with no bond, which he should be entitled to a bond on a misdemeanor, Judge.
But why did the magistrate make that decision?
Well, I'm guessing it was because he's on probation for.
Exactly. Under 1710(1), if you're on probation for something that involves, especially if it involves a possible violent offense, or if you're on probation, period, they will no bond you because you're not supposed to get another charge while you're on probation. That's the whole point, Mr. Lynch. You're not supposed to get arrested again when you're on probation.
And I understand that, Judge. However, the alleged violation, you know, is something that he adamantly contests, and something that he has a right to a trial on, and something that he will be subject to a trial on before you. And if there were to be allegations that he violated his bond, then the state could file a motion to revoke his bond. But to revoke the balance.
But the whole point is, Mr. Lynch, is the court doesn't do double work. And if the point is that I have a mechanism for revoking bond on somebody who's not on probation, who's not been sentenced yet, who's pre-sentencing, then that's the mechanism I use. But if I have a mechanism for somebody who is currently serving a sentence, then that's the mechanism I use. A petition for bond revocation is the correct mechanism in this case. I don't have to rely on a bond revocation.
And I understand you do not have to rely on that, Judge, but I would argue revoking the balance is not the appropriate sanction in this case, not just based on the fact that this appears to be his first charge where there's any violence alleged, also based on the fact of who he is, based on the fact that he complied with probation to a great extent, that he's reported to probation, that he has started to complete his community service hours. He tells me he's got at least 20 hours completed. My client is 38 years old. He has a son with special needs. He is currently working, I believe, at Church's Chicken. Judge, he is trying to be a productive member of society. And he, you know, to revoke the balance now and have him serve more time than the state typically asks for on someone's first violent charge, you know, Judge, I feel would be overly punitive, especially considering the strength of the evidence that was presented. And that it essentially, you know, it essentially punishes him for a crime that he has not been convicted of, Judge. And so we're requesting that he be returned to probation with the same conditions or such additional conditions as Your Honor would deem appropriate, and that he be you know, face jeopardy for this alleged offense when it comes up for trial.
All right, Mr. Jones, I do find that from a preponderance of the evidence that he's violated the terms and conditions of
Your Honor,
probation.
your camera is off. Your Honor, your camera is
Sorry.
off. Interrupt.
I hit it when I was trying to fiddle with these papers on my desk. Yeah, I do find that his probation, he's violated the terms and conditions of probation by preponderance of the evidence. I do find that it doesn't meet the, I guess the standard I would set for revoking the entire balance of probation, but he will serve 20 days. 20 days will be revoked. After service of 20 days, he's going to return to probation and continue all of the special conditions of probation.
Thank you, Judge.
All righty, I'm sending the order over.
Judge.
All right.
All right, so I'm ready to go forward on all of the other cases.
You're okay, you're all right, you're all right.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.